Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-5209, Judicial Watch Appellant versus United States Department of Justice. Mr. Peterson for the appellant, Ms. Stapleton for the appellate.
Good morning. Please proceed.
Good morning, Your Honors. James Peterson for Appellant Judicial Watch, Inc. This case is about an extraordinary government intrusion into the private lives of Americans. Now, not surprisingly, the government is trying to hide its actions. Credible evidence indicates that early in its January 6th investigation, the FBI sought and received financial records of anyone who used a credit card or engaged in financial transactions in the D.C. area on January 5th, 2021. This case seeks records to determine if such a wildly improper sweep of financial records of innocent Americans occurred. Instead of responding to the FOIA request in this matter, the FBI is hiding behind the ever more frequently used and frequently asserted and abused Glomar doctrine. In fact, the FBI claims that affirming or denying the existence of records.
I'm just curious, counsel, what's the support for your claim that the FBI has been abusing?
Well, you can see that over the years, the Glomar has been increasingly used by the agency. We see it in our practice. There are more court decisions every year.
According to my records, I only looked back 10 years. I only see 2 cases where we vacated a Glomar response. Do you know of more?
But there are more in the district court than there have ever been.
They weren't reviewed by this court, right?
In this court cases that make it to this court so far, yes. But what were those cases? It was the ACLU versus CIA, and the government made an increasingly preposterous claim.
Well, and we reversed that. We denied the access, but that's 2 in 10 years. I'm just curious about your claim that they're increasingly abusing it.
Right.
I just wonder where that's from.
Well, there are published studies that would be happy to supplement.
No, that's okay. You've said enough. Go ahead with your argument. Yeah.
But what the FBI is really doing is refusing to confirm or deny by using the Glomar that it conducted this improper fishing expedition into financial records. The Glomar claim in this case, however, is not consistent with the language or legislative purpose of FOIA or the Glomar doctrine. There is no law enforcement technique that will be revealed as using financial records, as the FBI admits, is a well-known investigatory technique to Americans. There is no danger that any secret or procedure or other information will be revealed.
Excuse me, but there's an affidavit from the agency which says that, which is directly contrary to what you just said. It said that there are, I think, over 300 cases still open. And if they admit or deny the existence of this, it could influence all of those cases.
Well,
you need to stick to the record here. You've got a declaration from the agency saying that revealing this information could jeopardize up to 300 cases, current cases.
We have a conclusory self-serving declaration.
Wait, why is that conclusory and self-serving? That's stated under oath by the FBI about 300 cases. Now, what is conclusory do you mean self-serving, that it's supportive of the FBI's case? Is that what self-serving means?
In this case, yes.
I see. So
every piece of
affidavit
is self-serving in any case.
Well, in this case,
a person wouldn't propose evidence to work when it helped the case.
And this court would have no role here if it was simply going to accept every statement made by.
So what's conclusory about it?
By simply saying that it will affect these open investigations.
Well, doesn't that sound right? The standard is, has the FBI shown a logical connection, right? That's what they have to show, because we don't know for sure. Doesn't it seem quite logical that if potential defendants know about this process, that they can take action to cover their tracks?
Well, more precisely,
what's the matter with that logic?
More precisely, Your Honor, excuse me, the question is to a reasonable person.
No. Please answer my question. The standard is, that logic is actually the word I think our court has used, right? Does it make sense? Is it logical that the FBI's, that it could be that this could jeopardize ongoing law enforcement activities? And I'm asking, what's illogical about that claim?
What is illogical is what's logical, Your Honor, is the idea that targets of the January 6th any person that may have been any tangentially involved, or any American at all, is unaware that the FBI uses financial records.
How about one of the 300 people who's under investigation?
I'm sorry, Your Honor?
I said, how about one of the 300 people who is still under investigation? How about one of them?
But the question is to a reasonable person, is it logical or plausible that the FBI might use financial records? The FBI admits that it's well known. There's nothing secret about its use of financial records. It's obvious to any person that's ever seen a crime.
But your FOIA request is not about like whether you use financial records. And I grant you that there's lots of information in the public domain from the criminal prosecutions that they have used from financial records. Get financial records by search warrant. They can get them by going through the trash. They can get them by subpoenaing the accountant, by the wife or someone else with possession, custody, or control, turning them over, by a defendant voluntarily providing them. There's lots of ways that they can get. What you have asked for are records of their requests to financial institutions. And that's what's not in the public domain, right?
I believe there is substantial evidence in the record.
Point me to some.
In the examples that are highlighted in our brief, the court documents filed by the FBI says they obtained, quote, obtained records from financial institutions. They didn't do that by waiting for somebody to drive by. And
what do you think of the district court's explanation about that? That is that there were 3 or 4 different federal agencies involved in this, and we don't know which one might have obtained it.
That is a distinction that makes no difference, Your Honor. The question is,
wait, why is that? You've asked for documents from the FBI, right?
Because the idea that
and the declaration says there are 3 or 4 other agencies also involved. So we don't know from, as the district court said, you can't tell from this whether it's the FBI or not.
Because it's a distinction that doesn't matter. The point of the source of the information is from the perspective of what you've been asking about, is from the perspective of a target, of a potential target of an investigation. It doesn't matter the route that the records got to the FBI. The question is whether they would be aware that the FBI might be accessing financial records. And the idea that the FBI is outsourcing its routes of information to the Capitol Police to obtain financial records is simply not plausible, which is the standard in this case. The FBI routinely uses this information it says in its documents that it obtained this information from financial institutions. There's more than enough basis that that's exactly what they did, is they communicated with financial institutions to obtain this. That's their function. For them to now say, oh, well, we might have gotten it in some other indirect way, strains credulity.
So do you give any weight to the point made that there may be this general information, but the precise techniques, the precise methodology used, none of that has been shown to have been either previously acknowledged or disclosed?
We do not, Your Honor, for the simple reason that this is not some secret procedure of a listening device or an unknown technology.
How do you know?
Because the FBI hasn't said that it is. I mean,
so silence is an admission?
Well, again, this is a standard. We have a standard here of what's logical and plausible. I mean, if this court wants to be a rubber stamp for an agency and accept everything they say and find any fine distinction to uphold it, that's your choice. But in reality, what it is these are relatively simple investigations where they were trying to identify. They admit this. They've done it many times. They were trying to identify the location of people, and they used financial records. So the idea that they communicated while in the process of doing this is simply common sense, with all respect, Your Honor.
Well, counsel, let me ask you then, in other words, under FOIA, as you read it, it doesn't matter if there are techniques and methodologies. If it's logical to an average person that in the course of a criminal investigation, an agency working in connection with that investigation would necessarily ask for financial records. And that covers the waterfront. And that's the end of any obligation and burden in your reading of FOIA. And I understand your arguments about, well, Congress defined the exemptions, and 70 has often been cited. But the court long ago came up with this GLOMAR approach. And so far, that continues to be the law in this circuit. And you're stuck with that, aren't you? And where you're not challenging here, as I understand it, the expertise that could have been involved. And I really don't see any claim of bad faith. But simply your argument is that the courts have set these standards too high when everyone knows that agencies involved in criminal investigations are going to seek financial records.
Well, you're correct, Your Honor, on 2 points. First, we agree that the GLOMAR doctrine, as is evolved under the law, it sets far too high a burden on a FOIA requester. But in this case, we're not asking here for you to change the law on GLOMAR. We know this panel cannot. But we're asking in this case for an application to these facts of exactly what the standard is, and not simply bless an implausible and illogical explanation from an agency that it did not do what it routinely does and says it does, which is to obtain financial records. We're simply asking for that level of review in not excessive deference under GLOMAR or FOIA to the statements of an agency.
So
I'd
I
like
guess
to-
I would come back and simply ask then, while you say you're not challenging Glomar itself, it seems to me that you are challenging some of our previous decisions as to how this court has interpreted the burden under 7E.
Well, we're certainly open to the idea that if it's necessary to seek en banc review or other to review the law, that is fine. But we don't believe it's necessary under these facts in this case to get there. But
Well, our case law says under Glomar, you have to show that the information requested is as specific as the information previously released. So how do you meet that?
because what we have is information in the record that confirms they sought, obtained, and used financial records from financial institutions. That's what we're asking.
Are you
for.
talking about the online article? Is that the one?
No, I'm talking about the court filings describing how they had prosecuted January 6 defendants and used financial data.
Specifically, you have one example, it's on page 11 of your brief from the US v. Kevin Douglas Creek case, where you quote from one of the statement of facts that financial records obtained from JP Morgan Chase Bank corroborate Creek used a credit card in his name to purchase gas, blah, blah, blah.
Yes.
So that you say is as specific as the information that you are requesting.
The question in the end is, is a court going to look for any possible distinction of the facts in order to uphold an agency's claim, or is it going to apply the logical, plausible standard of a reasonable person, which is what the law requires? In this case, a reasonable person looking at this, that they obtained records from the financial institution, or in the previous example on page 11, the bank provided records to the FBI. I mean, a reasonable person would interpret that as saying the FBI communicated with the institutions that obtained these records. That's not an implausible or in any way illogical conclusion.
Well, they could have gotten them in other ways.
I'm sorry, Your Honor.
I said they could have gotten them in other ways.
But I mean, there's theoretically an unlimited number of ways.
Right,
they're not very likely.
That's the whole point.
But it isn't the standard is not mathematical certitude. The standard is logical and plausible. And what's logical and plausible is the FBI, they ask these financial institutions to provide records. The FBI does this. The director of the FBI admitted this week before the Senate panel that it obtained user location identities of cell phone users by buying it from companies. Well, the FBI has a pattern of doing these things.
All right. Judge Rogers, do you have any further questions?
No, thank you.
Judge Tatel? All right. You've exceeded your time, but we'll give you some time on rebuttal. Let's hear from the government, Ms. Stapleton.
Thank you, Your Honor.
Good morning. Thank you, Your Honors, and may it please the court, Anna Stapleton on behalf of the government.
Morning.
This case is about whether the FBI must disclose whether it asked financial institutions for certain financial records as part of its investigation into the events of January 6th. And I'd like to begin this morning by focusing on 3 reasons why, as a practical matter, it is important that the FBI be able to make its Glomar response in this case. Those 3 reasons, in short, are because of the specificity of the FOIA request at issue here, because of concerns about a mosaic effect and because of the importance of consistently using a GLOMAR response across similar requests. So to begin with my first point on specificity, the FOIA request at issue here is not just a request for information about the use of financial records, generally speaking. It's not even just a request about whether the FBI communicated with financial institutions about financial records generally. It's instead a very specific request that seeks records of communication between the FBI and any financial institution, including the specified ones, in which the FBI sought transaction data for those financial institutions' debit and credit account holders, that's one piece of specificity, who made purchases in Washington, Maryland, and or Virginia, that's a geographic limitation, on January 5th, 2021, and or January 6th, 2021. So that's a temporal limitation. And of course, that request was narrowed to request for records of such communications made in the course of the January 6th investigation. That means that when if the FBI had to give a yes or no answer to confirm or deny the existence of responsive records, it would be giving a very specific answer about the kinds of information it sought, as well as, to Judge Tatel's earlier point, as to how it sought that information. If I may offer one practical example, suppose that a person came to January 6th, came to DC, participated in the events of January 6th, had arrived on January 4th, used a debit card to withdraw $500 in cash on the 4th, and then didn't use the card again on January 5th or 6th. That person would be very interested to know whether what the FBI sought was specifically records of transactions on January 5th and 6th, as opposed to on the 4th or on other dates. That leads me to my second point, which is about the potential mosaic effect. As the Seidel Declaration points out in a couple different places, one concern here is that FOIA requests don't exist in vacuum. There could be multiple FOIA requests asking about different kinds of techniques. That would include, for example, a second FOIA request that might also ask, did the FBI seek information about financial transactions on January 4th? It could include information about, requests seeking information about the other kinds of techniques that the FBI used. Did they, use video from security cameras in local businesses? Are they using facial recognition technology? By piecing together information from multiple different FOIA requests, it would be possible for both a January 6th participant and also someone who might be considering participating in a future event, similar kind of event in future, to piece together a comprehensive picture of how the FBI goes about investigating these kinds of events. January 6th is a particular kind of investigation. As Judge Wilkins mentioned earlier, it involved hundreds of people. Many of those people remain, I think it was Judge Tatel who was asking this question earlier. Many of those people remain unidentified. Hundreds of people came from all over the country, were in DC or the area for a short period of time, and then left. And the question is, how does the FBI go about investigating, finding out who those people were and what they may or may not have done? So to allow through multiple FOIA requests where the FBI has to say yes or no, we use this technique or we use this specific technique in this particular way, would potentially give those folks a great deal of information about how to avoid getting caught. And then to the third point about the importance of using the GLOMAR response consistently, GLOMAR, of course, means that the agency is neither confirming nor denying the existence of responsive records. Were the agency to only use a GLOMAR response, for example, when responsive records actually did exist, that would be a clear tip-off. So the agency has to use it both when records do exist and when they don't. Similarly, it's important that the agency use the GLOMAR response when there's been no official acknowledgement, potentially even if the public might suspect that they know what went on. As long as the public doesn't know, and Judge Wilkins, you were asking about, I think, the Moore standard for official acknowledgement and the specificity of the information that's been previously disclosed. As long as the public doesn't actually know, that specific information, it's important that the FBI continue to consistently use GLOMAR to protect it.
What do you mean, as long as the public doesn't know that specific information?
So, for example, in this case, Your Honor, and this was, of course, discussed with my friend, what the public knows because of the statements made in the criminal cases, and those are excerpted in our brief at page 28, and that, of course, also includes record citations. What the public knows is that the FBI at some point became aware of specific records for specific individuals. The public does not know. They may speculate, as happened in the news articles in the record. They may speculate about how the FBI came to obtain that information, but because
When the record says financial, when the statement says financial records obtained from JP Morgan Chase Bank, what is the public or anyone to take from that as far as who they came from? Says obtained from JP Morgan Chase Bank.
So the key, Your Honor, is that it says they came from the bank, but it doesn't say to whom or how. So, for example, as was mentioned earlier, if those records were given to another law enforcement agency and then passed on to the FBI, that scenario would not create responsive records. In this case, similarly, if they were obtained pursuant to a subpoena, the FBI, in analyzing this request, determined that a subpoena would not constitute direct communications between the agency and the financial institution. There's one mention in the record of a subpoena. I would also note it doesn't say who sought the subpoena, right? So again, it could have been another law enforcement agency.
Say that again, you're saying that a subpoena is not a direct communication between the FBI and the recipient of the subpoena?
That's correct, Your Honor, because it would be intermediated by the court, potentially by a U.S. Attorney's Office. And again, I want to be clear, the other possibility is that a different government agency or a different law enforcement body sought the subpoena in the first place.
And you're saying that the FOIA request was for communication, not subpoena?
Correct, Your Honor. So the request was for records of communication between the FBI and any financial institution.
What about the more general point that, I mean, you don't have to be a rocket scientist to know that the FBI subpoenas financial records as part of their investigation?
That's right, Your Honor. But we would say, again, I would direct you to the specificity of the request. So this is, did the FBI not just look for financial records generally, but did they look specifically for debit and credit card records from these 2 days in this geographic location? And did they do so as part of this investigation? So that's a lot of information. I gave the example earlier of someone who only used a debit card on January 4th. We might also consider a person who only used other kinds of financial transactions, made transactions through like electronic transfers, made a withdrawal of cash, but didn't use a credit card, right? All of those details are the kinds of information that would permit someone to potentially think, oh, I'm at risk. That person who believes that they're at risk may well go about trying to make prosecution of them more difficult, may consider destroying other evidence, such as photos, take down social media posts, that kind of thing. It could also mean, and this court said in Mayor Brown, it matters if if the agency would have to provide information that would inform someone they're not at risk of prosecution. And so if someone, for example, my hypothetical person who used the card on January 4th were to discover that their financial records were probably not obtained, they might be less likely to put themselves forward. And I'd like to emphasize, I see that my time has run, but finally that those same concerns are present for people who might participate in future events.
Why wouldn't the FBI's concerns be dealt with just by applying the exemption under 7E instead of GLOMAR response? And perhaps with them acknowledging, yeah, we have records, but for various reasons, um, we intend to withhold various, the records themselves, and even only give some sort of very generic description of the records that we have, so that it doesn't disclose what days, we communicated precisely. So it may be that we have records from the 5th and the 6th, but that doesn't mean that we don't have records from the 4th and the 8th. So why can't this be taken care of under the exemption instead of under GLOMAR?
So the problem, Your Honor, is again, because of the specificity of this request, simply answering yes or no, we do or do not have responsive records, would give away all of the details that are built into the request itself. So on the one hand, just saying yes or no on this request, if the agency were, for example, to say yes, it would mean that they did specifically ask banks for credit and debit records in that geographic area on those 2 dates. Right. So that's one problem, is you've already had to give away one very specific set of information about how the agency approached investigating this case. The second problem is, again, going back to the mosaic issue, which is to say there could be other requests. And if the FBI had to say yes or no on this request, they would probably have to say yes or no about a request about, did you ask for
Why won't we just cross that bridge when we come to it? We say, okay, you can't do GLOMAR here. And if there's another case and there's another request and it raises the mosaic problem, then the official puts that in their affidavit at that time, and the court considers that.
So, Your Honor, I think, again, to be clear, this piece of information is valuable on its own because, again, simply the yes or no answer here gives very particular information about exactly what the FBI sought. Whether the answer is yes, they did seek that, and so folks know that they might have been identified that way, or no, the FBI didn't seek this information, and so folks might know that they're in the clear. But the concern, the mosaic concern is not one that this court has required to sort of wait and see in the past. So it's discussed in Mayor Brown that, of course, when this court rules on a GLOMAR response, it's making a ruling of law that the agency has to consider in making its responses going forward. And this court said in Mayor Brown in 2009, one of the concerns was that in other analogous contexts, I'm quoting here, similar information could be sought. Everyone seeking in that situation to minimize tax liability, it was a case against the IRS, would love to have all the IRS's guidelines for all the other schemes to learn when the agency is likely to seek enforcement versus when the agency views the specific context as too difficult to litigate. But this court said that that meant that the IRS could protect that information because it was both important on its own and because of the risk that folks could put forward FOIA requests and seek other related information and put together that comprehensive picture.
Judge Tatel, any questions?
No.
Judge Rogers, any questions?
No, thank you.
All right, thank you, counsel.
Thank you, Your Honor.
All right, Mr. Peterson, you were out of time, but we'll give you 2 minutes for rebuttal.
Thank you, Honor. I would just, one point I would just like to briefly add is the point made by the FBI in its brief and by counsel here that this GLOMAR, this FOIA request should fail because of the GLOMAR assertion, because there might be other cases, there might be other FOIA requests coming up. Is an assertion that this court should look at very closely as representative of the perspective in which they're approaching. There's no basis in the law or any common sense for limiting, for upholding a GLOMAR here because of what might be happening in the future. We ask this court for the kind of searching review that the law requires and not to give the excessive deference that the government is asking for in this case. Thank you.
Thank you. We'll take the matter under advisement.
Case number 22-5176, and Citizens United PAC appellant versus Federal Election Commission. Mr. Hancock for the appellant, Mr. Casasa, amicus curiae.
Good morning, Mr. Hancock.
Morning, Your Honors. May it please the Court, Kevin Hancock on behalf of Helen and Citizens United. Your Honors, we respectfully request that this Court reverse the District Court's denial of End Citizens United's motion for default judgment. The District Court erred by relying upon a post hoc rationalization that purported to explain the Federal Election Commission's dismissal of End Citizens United's administrative complaint. Under black letter administrative law, judicial review of agency action is limited to the reasons invoked by an agency at the time of the challenged action. And here, despite that, the District Court relied upon a statement of reasons issued by the FEC months after the challenged dismissal in this case, after litigation challenging that dismissal had already been filed, and indeed after the 60-day statutory deadline by which any party could file a challenge challenging that dismissal. Now, critically, the District Court's decision to rely upon this statement did not rely upon any finding that the statement was actually timely or issued contemporaneously with the dismissal. Instead, the District Court offered three other reasons not related to timing, and all of which are erroneous for the reasons which I'm happy to explain now in turn.
Let's suppose we agree with all of that. Just suppose, for the sake of argument, that under Regents, we can't, the District Court should not have considered that statement as far as whether or not the decision that was made, I guess, in April of 2021 was consistent with law. Under our precedent, the remedy would be if the District Court could do one of two things. It could say either that statement wasn't robust enough to allow review, or that statement itself was contrary to law, and the commission has to have a do-over. I don't really see your complaint making the latter argument. So it appears that your claim was really that that statement wasn't sufficient to allow review. Well, under common cause and DCCC and our case law, relief you get is a remand for a better explanation, a more fulsome explanation. And you got that more fulsome explanation after the lawsuit was filed. So maybe you had a claim when the lawsuit was filed, but why wasn't your complaint moot essentially once that subsequent statement was issued? Because there's no more redressability at that point. You've gotten the relief that you would have gotten had you won your lawsuit.
Your Honor, our argument is that the dismissal is contrary to law because it's unexplained. Because on the administrative record, which cannot include... And
if you win that, you get a remand for an explanation, right?
Under Regents, it would be our position that the correct path would be remand for the agency to consider the issue afresh.
Why is this isn't a Regents case. This is not a Regents case. This is the question, this requirement for the controlling commissioners to file their explanations. This is all a creature of this circuit's case law, right?
That's correct.
Okay, so isn't that right? So the question we should be focusing on here is so in many cases, quite a few cases, we've reviewed statements like this that come late and found them perfectly adequate for judicial review. True, we haven't decided this issue before, but we have. So shouldn't we be, and I'm not saying that's the answer, but isn't the question before us really what resolving this issue, we should do so in a way that promotes the purposes of our case law here. And the purposes of our case law is to create a record for judicial review. That's it, right? It's not a Regents case. This isn't an APA case at this point.
Well, we would submit that the FICA case law that has addressed the specific application of these principles in the FEC context, so like ECCC, common cause, new models, that they are consistent with those background principles described in Regents. And
well, it's fine, but still, I think the question you have to answer is why, since we impose this requirement to promote judicial review, what is it about allowing the district court considering a statement that came from the same two commissioners, same reason, and it's before, yes, after the complaint was filed, but before anything began in the district court. So what precisely allows, what precisely means that the district court can't consider that because it isn't an adequate basis for judicial review? Isn't that the question?
Well, yes, Your Honor, we would submit that judicial review is actually undermined by allowing the commission.
Exactly, that's the question. So why is that?
For a number of reasons. So first, an untimely statement fails to promote reasoned agency decision-making because it makes it more likely that the statement issued late and indeed after the deadline for litigation is a convenient litigating position put forth by members of the commission.
Well, we know they exercised, we know they asserted prosecutorial discretion, correct? We know that. And this statement just explains that. They haven't changed their position. Is your point that, well, maybe this is stronger than it might have otherwise been had it been issued simultaneously?
No, we would say that if Your Honor is referring to the failed vote to dismiss pursuant to Heckler, that cannot act as an initial explanation of.
No, I agree with you about that. Actually, I agree with your brief about that. But my only point is there's nothing post hoc about this statement because it all it does is explain the exercise of prosecutorial discretion, right?
No, Your Honor, we do think it's post hoc. So it's inconsistent with this court's decision in new models. In that case, which is a case that explains and enunciated that where a statement rests upon prosecutorial discretion, the agency's failure to go forward is not reviewable. Despite holding that principle, that court still nevertheless reaffirms DCCC and its requirement that the commission, the failure to go forward commissioners, issue a statement of reasons, explaining their rationale. And it explained that the reason for that is until the public and the courts are able to see that statement of reasons, it's not clear whether the commissioners have actually effectively asserted prosecutorial discretion in a way that would shield the dismissal from judicial review.
Let me try to understand what you say we should do at this point. What you say we should do is to hold that the statements that were made, now there were two votes that were taken, one on April the 20th and one on April the 22nd.
That's correct.
That whatever the statements were made by the two controlling commissioners in those two votes were insufficient to allow the court to review.
Well, just to clarify one point, the statements made by commissioners were made more than 2 months later in their statement.
Well, okay. Whatever was said at that time of those votes, whether you call them statements or the orders or the minutes, whatever we have, the record from those two votes is insufficient. And therefore we can't review. So under common cause, et cetera, we should remand, but instead of remanding for further explanation and just ignoring what they did 2 months later, they have to have a do-over of the vote? Or are you saying that we just ignore what they did 2 months later and remand for further explanation of the previous vote? Which of the two are you saying we should do?
For new agency action, Your Honor, because an unexplained agency action is arbitrary and capricious and therefore contrary to law under FICA. The statute says—
But we've never held that before. We never held that in common cause, right?
Well, that—
We didn't say new agency action. We said further explanation.
So in DCCC, the court— and Your Honor, I see my time has
Answer my
expired.
questions until I tell you to stop.
In DCCC, the court did remand to the agency for further explanation. But in footnote 6 of that decision, this court also did specify that it rejected a post hoc explanation the FEC attempted to, in litigation, put forth to explain the unexplained dismissal at that time. And when it remanded and when it sent it back down, I don't know that the court was 100% clear whether it was requiring new action or just further explanation later on. But in either event, that decision was the first decision this court, where this court had ever held that the FEC has to issue an explanation or a dismissal resulting from deadlock. So it makes sense that the court—
Well, this is very important. I mean, even Regents says, look, there's two things that can happen if there's an insufficient explanation. You can remand for a more robust explanation of the previous action, or you can remand for action anew. The Chief Justice's opinion makes that clear. So we have a choice. What I'm saying to you is I've never seen a case where we have articulated that under this doctrine, the common cause, DCCC, whatever you want to call it, doctrine, that we do the latter, which is for the decision anew. Can you point me to any instance where we have?
I am aware of no decision in the FEC context, but I would like to add that in Regents, in describing that first path, the Chief Justice specified that that first path is only available if there was some initial explanation indicating the determinative reason for the agency's decisions, akin to the Duke memorandum in that case. And here, there's nothing in the record that's akin to that as an initial explanation that could then be later supplemented by this late statement.
I'm sorry, did you want to continue?
Go ahead.
Oh, because I'm going to just continue with your question. I had the same question, Judge Wilkins. Let me try to get at it this way. Let's assume that we agree with you that the district court should not have considered the late filed explanation, and that the proper remedy is a determination that the commission has failed to give a reason for its decision. And therefore, what would we do? Would the district court enter default judgment at that point? Whether it does that or not, here, let me get to my question. Under the statute, the commission has 30 days to conform to that declaration. But well, let me step back and ask you a question, and then I'll come back to that. Okay, this is all about preserving your right to go to court, right? That's what you want to be able to file your own suit after this is over, challenging these actions under the statute, right?
Preserving that right.
You want to preserve, that's what this is all about. Okay, so if this goes back one way or another, either because we remand or just enter judgment, the commission under the statute has 30 days to conform its conform with such declaration, right? That's what the statute says.
That's
So
correct.
what is that? So suppose at that point, the two commissioners reissue their statement. And they say, okay, court, you didn't consider this because it was too late. You've now said there was no explanation given because there wasn't any on the record, but now here it is. And that's unreviewable, right?
Well, it would be our position that the agency would have to engage in new action. So there's a number of possibilities there. It could decide to go forward. It could.
Well, it's not going to do that. I mean, at least I don't think so. That would solve the problem. I agree. But suppose it doesn't.
Your Honor, if I may offer reasons why that might be a possibility.
Yeah, go ahead.
So the commission is composed differently now than it was in June
I
2021.
see.
There's a new member that wasn't there before.
Uh-huh.
Additionally, facts before the commission have changed. The statement of reasons that was issued in June 2021. One of the key reasons those commissioners cited for exercising prosecutorial discretion is the commission had just had a long period of lacking a quorum. It had just regained that quorum and then cited a backlog resulting from that quorum. Conditions presumably have changed a year and a half later. I don't know what they are, but the commission could decide based upon the new landscape that exists today that a different action is appropriate.
Okay, so I see. That's helpful. So under your theory then, if we agree with you that district court should not have considered this and enter judgment in some way for you, that what happens before the commission, that there's nothing before the commission basically has to start over, right?
Correct.
Is that right? It has to start afresh and make a decision on what it's going to do about the charge pending before, correct?
That's correct.
I'm sorry, just one last question. Would we remand? Would we enter order default judgment? What do we do if we agree with you?
I think the court could reverse and with directions to enter default judgment and along with the declaration that the agency's dismissal was contrary to law, that would require the district court then to remand to the agency under FICA for the 30-day period you referenced. It's also possible that during that 30-day period, the commission might do nothing, in which case that would trigger
Then you could
Citizens United citizen suit rights.
Sorry.
So what is your best authority for why the commission would have to essentially start anew and take a revote as opposed to allowing the controlling commissioner to buttress their reason?
Aside from Regents, I would cite AT&T versus GSA as an example of a case where there was unexplained agency action that later the agency attempted to use a post hoc explanation to explain. This court rejected that post hoc explanation and then remanded because unexplained agency action is necessarily arbitrary and capricious. That was
so no FICA case you can cite to me, right?
I'm not aware of a FICA case that presents these precise facts. I would reference Commission on Home.
Any FICA case involving any FICA case any FICA case that involved an insufficient explanation. You can't cite any.
Commission on Hope. Commission on Hope specifically said that it's impermissible for a commissioner to update the administrative record after litigation is already pending.
That was a non-controlling commission.
True, but that factor was not dispositive in this court's decision because it accepted a separate statement of reasons that was given by also other non-controlling commissioners. It accepted it because it was timely. And we think the district court should have followed the Commission on Hope precedent. It tried to distinguish it on those grounds, but again, going back to Regents, the problem with post hoc is not the person, it's the timing. And I think Commission on Hope illustrates that principle.
So you're saying that our line of cases that said that the remedy is to remand for further explanation essentially can't work anymore, I guess, just as a matter of APA administrative law, post-Regents. That's essentially your.
Well, I think Regents is just exemplary of the underlying foundational kind of case law of this court and the Supreme Court on administrative law, which the FEC is one application of. And, you know, admittedly, not all of the cases are tremendously clear about applying the rule against post hoc rationalizations, but we do think that the Chief Justice in Regents was very clear. And so to the extent there may be conflict in the past with Regents' very clear explanation of these two permissible paths, Regents should control.
Well, I mean, generally speaking, I mean, the debate between the Chief Justice and the dissenters on that point was about most of the post hoc cases, rationalization cases are instances where counsel, in the course of defending the agency action, is raising something, and courts have said, well, we're not going to accept that. And so the dissent said, you know, that's why post hoc rationalizations are bad, because they are being propounded by counsel instead of the agency. And I think the Chief Justice found one example that he cited in Regents, I'm trying to remember the case, where he said that no, that was an instance where we said that post hoc rationalizations were bad, even in the agency context. But in general, that has been the problem, is that they're not just too late, but they're also by counsel. I think what Regents did was make clear that no, the rule is that if they're too late, then they're a problem, and they're a problem because they kind of inhibit the courts from being able to review properly. But that just brings me back to my original question to you then, is even if I agree with all of that, that still doesn't necessarily apply to this line of cases where we have always said, kind of even knowing that the new reasoning is going to be post hoc and after there's been litigation, where we have said the remand is for further explanation, not for a do-over. So it seems to me you've got to say your position has got to be that Regents changes the landscape, right?
Well, I don't think it necessarily does, because common cause was very clear that the statement of reasons required by DCCC must be issued at the time of the agency's action. And so that requirement is consistent with that background principle of administrative law articulated in State Farm and other cases.
Well, if that were the rule, then why, years later in common cause would we say, okay, we remand for further explanation instead of for a do-over? I mean, there would be no reason to even talk about further explanation. The remedy would just be do-over, because the statement has to be at the time you make the action.
Given Regents' very clear statement that there must be some initial explanation that could then be later supplemented, we would submit that anything inconsistent with the Chief Justice's ruling in that opinion is inconsistent with current law.
Well, if the initial statement or order, however brief, uses the words prosecutorial discretion and Heckler v. Cheney, isn't that different because of just the nature of that type of a reason?
No, because New Models precludes that theory, Your Honor. New Models held that the Commission's invocation of prosecutorial discretion in a statement under certain conditions shields the dismissal from judicial review. But nevertheless, New Models was very clear. The way we determine whether the agency effectively did that is we look at the statement of reason. The new model specifically reaffirmed the court's holding in DCCC. And there's a very good reason for that, a good substantive reason. It's because the courts and the public cannot determine whether the invocation of prosecutorial discretion was effective in order to insulate the opinion from judicial review, unless the commission expresses the reasons why it wants to assert prosecutorial discretion. As the new models panel explained, and as was later supplemented by the author of that opinion, Judge Rao, in her concurring opinion in the denial of rehearing en banc, even though a statement that partially asserts prosecutorial discretion is sufficient to insulate the statement from judicial review, nevertheless, that portion must still be independently based upon traditional discretionary factors, such as resource allocation and the like. To the extent that the commissioners say, we want to invoke prosecutorial discretion, but they do so because they have a dispute about the legal reason, the interpretation of FICA. That interpretation of FICA is still nevertheless subject to contrary to law review under the unique judicial review provision of the Federal Election Campaign Act, which makes the FEC, of course, very unique from other agencies and when they assert prosecutorial discretion. Hence the need for this statement.
Judge Rogers, any questions?
Well, one thing, counsel, I take your point, but after all, a judge's statement on denial of rehearing is not the same as a decision of the court that's binding. But that aside, what about our decisions where we have said that where an agency is simply elaborating or it's not changing its basic position as to why it's taken the action it's taken. But the court says that may be well and good, but we need a further explanation. So we send it back. So we've acknowledged, in effect, your situation, haven't we?
No, Your Honor.
Yeah, go ahead.
There must be something to elaborate on in the first place. I think it's what Regent says very clearly. And here we submit that there was no initial explanation in the administrative record for why the agency dismissed this dismissal. The statement being so late and being post hoc is not part of the administrative record. The record is silent.
Well, so what I'm getting at is it's not as though we have allowed the agency to say, well, we talked about prosecutorial discretion immediately. Now we're talking about timeliness. So we haven't gone that far, but we have, in many instances, given the agency another opportunity. And indeed, if the agency changes its rationale, then a new rulemaking may be required. But I'm just trying to understand. It's very nice if we just say, well, Regents, we have a clear rule. Now we know what it is. The agency knows what it is. And, it will, as all these agencies do, come up with what I call some standard language as to what it means when it says it's invoking prosecutorial discretion. And the standard will, it could say backlog, but maybe there is no backlog anymore. So won't reference that, but it'll talk about other factors that cause it, in this case, to decide that it would not be a wise expenditure of its limited resources. So I understand about it's important in administrative law that agencies follow the law and not try to circumvent it, but this is not really that case, is it? And that's what I think is making us uncomfortable. Now, your point about how even in these other remand situations, the courts have acknowledged, well, times change. Maybe not in 2 months, but by the time the case gets up to an appellate court and then goes back to an agency. And even so, an agency member may simply change his or her mind. It's one thing to do it sort of summarily, it's another thing to have to say why, and maybe that discipline in itself is enough to assure that we're not having arbitrariness. And the argument is, well, you're trying to protect your right to get into court. And so I think it's not necessarily as easy as you want to make it, but we'll have to figure out how to make it clear, because I think that's part of the problem right now.
Your Honor, if I may, I think the value of requiring the commission to express whether it's trying to invoke its prosecutorial discretion at the time of the actual dismissal is that it vitiates the risk that the agency is simply using prosecutorial discretion as a convenient litigating position. Here, this statement of reasons was issued 4 days after End Citizens United filed its lawsuit. The statement is fewer than 4 pages. It invokes prosecutorial discretion, and thus seems to fit a pattern observed by some on this court that there's been a significant uptick in the commission reflexively asserting prosecutorial discretion to explain its dismissals since the Commission on Hope and New Models rules that insulates the commission's failures to go forward from judicial review, which we would view as a change in the law.
Help me. Go ahead, Judge.
Could you just explain to me once more what, assuming you win here on your theory that the district court can't consider the statement, could you just explain to me once more the role of the conforming language in the statute? That what role will it have on remand? What will the agency be conforming its decision to?
To the district court's order declaring the dismissal contrary to law.
Oh, okay, and when it does that, will it, that I got that much. But what exactly does that mean? What will it, suppose the commission, contrary to your hope, doesn't change its mind. Suppose it sticks with this action. Is it your point that it can no longer explain away the first decision, that it has to start over again? Or could it now just issue an explanation of why it exercised prosecutorial discretion?
It has to start over again.
But why? It says conforming. I see. So your point then is that what is contrary to law is its failure to give a contemporaneous reason, right? That's what's contrary to law. And the only way it can fix that is by starting over again, because if it issues a new statement, that's even later, right?
I guess I would say
is that
the dismissal itself is contrary to law. The dismissal itself is illegal because it was unexplained. Because it was
unexplained, and the reason it can't remanding it for the commission to repeat its explanation is that explanation would now be, instead of just a couple of weeks late, several years late, right?
Well, that, and there must be something to explain. So if the initial dismissal is illegal under the contrary to law standard, the commission has to.
Well, no, the original dismissal wasn't. It was for prosecutorial discretion. That's the reason they gave in that note, right?
In the post hoc statement, which properly should not be considered part of the record. And so on the record, which should exclude that statement, the dismissal itself is unexplained.
I'm sorry, didn't the record before the commission indicate that prosecutorial discretion had been asserted? There was just no reason given? Am I wrong about that? I thought that appears on the record.
There was a vote held to dismiss the case pursuant to Heckler v. Cheney, which is a vote the commission often takes.
Yeah.
That vote failed 2-3. The two commissioners who also voted against finding reason to believe, against moving forward with the enforcement action, are the ones who voted in favor of that Heckler motion. It has been suggested that that vote in and of itself could serve as a sufficient initial explanation that could then be later elaborated on. But our friend has cited no case law indicating a vote in and of itself could be an explanation. And that theory is concluded by new models DCCC, which again requires a statement of reasons, despite the fact that prosecutorial discretion does have this insulating effect.
So just so that I understand how this works, on April 20th, 2021, and this is at your appendix at page 86, there's a certification about what occurred. I'm sorry, there's a certification about what occurred on April 20, 2021. And the first item listed are what were the results of votes about whether essentially actions that were taken were contrary to FICA, right?
Correct, under this reason to believe statement.
Whether there was reason to believe that certain actions were contrary to FICA. And those votes failed by a vote of 3-2, because there were 3 commissioners who thought, yes, there's reason to believe, and 2 who said, no, I don't think there's reason to believe. And then 2 days later, on April 22nd, and that's the certification that begins at A90, we see that there was a vote on whether to dismiss under Heckler v. Cheney this claim, and there were 2 in favor of dismissal and 3 against, and it's the same 2 who found no reason to believe, and so those 2 are the controlling commissioners. And to the extent that we have any contemporaneous statement, if you want to credit that as a statement, that's what we have at essentially at A90. Is that your position? Is that a correct understanding of the record here?
That is what occurred. We would take issue with the characterization of the vote to dismiss under Heckler as any kind of statement. And I think that characterization would be inconsistent with not only FEC procedure, but this court's case law. So again, going back to DCCC and its progeny, the vote that matters for purposes of explaining a later dismissal, which here is the 5-0 vote, close the file, is the failed reason to believe vote, the deadlocked reason to believe vote. And the statement of reasons must explain why the failure to go forward commissioners voted against reason to believe in that vote.
Well, help me understand that, because we're reviewing final agency action. So this is a final agency action. You're saying that we get to review both of those votes, not just the April 22nd vote, but also the April 20th vote?
DCCC has said that for purposes of evaluating the dismissal, which technically occurs with the 5-0 vote, the substance of the reasons why it was eventually dismissed, the failure to find reason to believe, is what the court looks to in order to explain that later dismissal. And accordingly, the Commission's own enforcement guidebook says a statement of reasons must explain why the failing to go forward commissions declined to adopt the General Counsel's recommendation that we find reason to believe. So the Heckler vote and the RTB vote are different votes. They ask different questions. And again, in DCCC, this court said a statement of reasons is required, even if we assume all deadlocks are at some level an exercise of prosecutorial discretion. The FEC made that argument. They cited Heckler, and they said, look, all deadlocks are just prosecutorial discretion. We don't need judicial review or a statement of reasons. And this court disagreed in that case and said, no, a statement of reasons is still required, even assuming that that's true. This is a similar, I would say, a variation on that same argument.
So the certification is dated on May the 5th. What's the significance of this certification? Is the date of the certification the actual date of the final agency action?
No, Your Honor, it's the date of the actual vote. The date of the certification is just the date that the commission secretary certifies that record reflecting that the vote occurred on that date.
So just so that I understand this, because we judges need to understand practical realities of whatever we order or don't order. You're saying that at the time that the vote, that they show up for the meeting for the vote, they should already have written out all of their statements so that that could be placed in the record at the time that they vote to dismiss any further enforcement act.
No, Your Honor, we don't think any rule needs to be that rigid to satisfy the at the time requirement or the contemporaneous statement requirement. Our position is that a logical outer boundary for that requirement could be the 60-day deadline in order to file litigation challenging that dismissal. Because again, to the extent that the rule against post hoc rationalizations is concerned with preventing agencies from explaining their actions with litigated positions, it makes sense to prevent an agency from waiting till litigation is filed, looking at what's filed, and then submitting an explanation for their long past action that is geared towards responding to the litigation.
So help me understand, is the deadline to file the litigation, the clock starts ticking 60 days later, or you have up to 60 days after the action to file your litigation?
You have up to 60 days from the date of the file closure, the filed litigation. So from the date of the April 22nd, where the 5-0 vote. So you could have filed your case on April 23rd, and it would have not have been premature. That's correct.
Counsel, the problem with your 60-day deadline, though, is you can just see it in the next case coming up. All we knew as of April 23rd is the commission had some reference to Heckler v. Cheney or prosecutorial discretion, but we don't know why. And we're not going to know that until the date by which we have to file our action in court, or our notice of action. I think there's some unreality to that. I mean, before you know that you want to file an action, you want to know what the agency's decision is, I thought.
I would agree with you, Your Honor.
And if the agency comes up with, just hypothetically, a 10-page explanation of why prosecutorial discretion makes sense in this case, you might decide, there's no point in filing litigation, but you're not going to know that until the day your notice of filing is due. I don't understand that as just a practical way of understanding how the process would work. I understand the practicality of not requiring a commissioner to come to the meeting on whether to close the file with a written statement, but I mean, maybe something, I don't know, 72 hours. I don't know what it would be. I mean, the commission could make that decision initially, but I don't. Go ahead, excuse me.
Sorry. We sympathize with that concern. When we decide whether to file litigation challenging a commission dismissal, we would prefer to see the commission's statement of reasons explaining the reasons for the dismissal first, so we can determine, should we challenge this? Is there a basis for challenging it or not? It smacks of gamesmanship to allow the commission to wait out the statutory deadline to preclude organizations like Citizens United.
Well, then I don't understand why you would agree with it, all right? I don't need to understand your reason, but I just wanted you to know I have certain concerns about that approach. I mean, we're setting ourselves up for a lot of other litigation. I don't.
Can I guess what we're struggling with here is the workability of your 60-day rule. You're the litigator, not me, but I assume what you would do correct me if this is wrong. I assume what you would do, you get a decision on day one that starts the clock running, and you wait the 60 days for the commission's explanation, right? The controlling commissioner's explanation. It comes on day 30 or 40, then you can make a judgment about whether to file a lawsuit, right? If it
No,
doesn't
but
come till,
my counsel, but
if it,
my
if it doesn't
co,
come till,
no, he's saying it comes on day 60 or day
well,
59.
I was about to finish. That's where I was going. I assume if it doesn't come till day 60, on day 60, you file your lawsuit. And if a week or two later, turns out to be satisfied with the commission statement, you withdraw your lawsuit, or if you decide to continue, you amend your complaint to reflect what the commissioner said, right? Isn't that what you would do?
That's correct, and we did something similar in this case, given the late statement of reasons. But I would submit that this does not lend itself to orderly judicial review, which is one of the reasons Chief Justice Roberts said in Regents that we require timely statements and not post hoc statements.
Right, but you yourself said you would, when Judge Wilkins asked you what the outer limits is, you said it's 60 days, and I assume that that's okay with you. That's your interpretation of the statute, and therefore that you would then have to deal with the problem that both Judge Rogers and I raise. What happens if the explanation comes on day 60, right? And you would just be ready to file your lawsuit that day, right? Isn't that the way it would work?
That would be feasible. We think the 60 days is a workable outer boundary, but not necessarily where the court has to land.
You know, would you would rather us say 30 days? But I don't know. I guess since we're making this up, we've been making this stuff up for all these years, we can make up some more, right?
There would be some logical to a 30-day rule. The commission does release the administrative, right? What they call the MER file, the matter under review file. So they're basically the administrative record. They release it 30 days after the dismissal, after
Oh, that's interesting.
closure of the file.
And that's by regulation?
I believe that's right.
Yeah.
I believe that's right.
So let's suppose on April 22nd, the commission acts and declines to proceed. And the very next day, someone files. And then, you know, within on the 60th day after April 22nd, the commission issues, the controlling commissioners issue a statement. Can the district court consider that statement?
Well, I wouldn't pin the rule to exactly where in the timeline the complainant files its suit. And I think the reason for that is you know, the concerns about post hoc statements go beyond merely just.
I didn't ask for a rule. I asked for an answer to my question with my fact.
Under the proposed rule, the outer boundary of 60 days, if it was within that, then yes.
So that post hoc statement, after they've seen the complaint and after litigation has commenced, that one's okay.
Under a 60-day rule.
And why is that consistent with Regent?
Because it still doesn't lend itself to reasoned agency decision making. You know, Regents gave a number of values promoted by timely decision making. You know, the gamesmanship aspect was just one of them, but in addition, agencies make better decisions when they're required to grapple with the reasons for why they're acting contemporaneously with their action. It gives them a chance for self-reflection and correction. You know, maybe their decision making is improved if they are forced to articulate it at the time of the actual action before it's too late.
Can we go back to your answer? I'm confused. Can you go back to your answer to Judge Wilkins' question? I thought you said that, am I right that if, under your theory, under your view of this, let's assume we go with the 60-day rule. If the commission's statement comes, if the controlling statement comes after 60 days, it can't be considered, right? Isn't that your view? Period.
Correct.
Okay.
But my question is, day one, the commission declines enforcement.
Yeah.
Day two, someone sued. They say, set aside the decision as contrary to law because there were no there was no explanation. You can't review them. After you have filed your suit, but within day 60, the controlling commissioners issue a statement. And my question to you is that statement timely, and can it be considered by the district court? And your answer was yes, right?
Correct. Under a 60-day rule.
As long as it's issued within that 60 days, right?
Correct.
So
Now,
the district court, I assume what would happen is the complaint would be filed on day 2 under Judge Wilkins' hypothetical, and the district court would say, okay, we're not going to do anything until day 60. See if the commission gives a reason. If it does, then we've got a case. If it doesn't, then we won't consider it, right? Is that what would happen?
correct.
Okay.
And I think there necessarily has to be some balancing between the concern about post hoc statements, but also giving the commission sufficient time to articulate its reasoning. And again, the standard is at the time or contemporaneous. It isn't precisely.
Well, I think this takes us back to where Judge Wilkins started.
So we're way over time here. Judge Rogers, do you have any other questions?
Well, I have a general comment. I don't think this is the proper forum for the court to try to come up with a rule to define the agency. And you know, all three of us are former litigators. And I'm just wondering about the system that we envision here. And the Chief Justice was also a former litigator. So anyway, I have no further questions. Thank you.
All right, Judge Tatel, no further questions. All right.
Thank you, Your Honor.
We'll think about giving you some time on rebuttal. All right. How about we hear from our court-appointed amicus, Mr. Casazza?
Thank you, Your Honor. Good morning, and may it please the court, David Casazza as court-appointed amicus. This court has repeatedly held that the FEC has unreviewable prosecutorial discretion to decide whether to bring an enforcement action. Two commissioners invoked that discretion when they voted to dismiss the allegations under Heckler versus Cheney. They later expanded on their reasoning in a statement of reasons released soon after. And Citizens United identifies no case in which this court has declined to consider a statement of reasons released by the controlling commissioners. Never mind a statement released on a similar time frame.
Of course, we've never decided that question either, right?
It hasn't been decided, but in a number of cases, this court has.
Yeah, we have, but we haven't decided the question. This is an open question right now, right?
That's correct.
Okay, fine. So go ahead.
Even assuming that such a gap in time were relevant, decades of case law, including Regents, make clear that when the determinative reason for an agency action is apparent in the record, the agency decision makers may later elaborate on that reasoning with a supplemental explanation, which is what took place here. Moreover, the remand that End Citizens United seeks would be what Common Cause called an exercise in futility and a waste of the Commission's resources. This court has repeatedly held that remand is not appropriate when the agency's reasoning is readily discernible and remand would bring no change in the outcome. And I think Common Cause is a good place to look in answer to Your Honor's question about what would happen on remand. The court there makes clear that what they're asking the agency.
I'm sorry to interrupt you. I was thinking about your statement that this is just an explanation of an earlier decision to exercise prosecutorial discretion and that agencies can update it. End Citizens United, they say in their reply brief that the failed Heckler vote wasn't what dismissed the case. That didn't occur until the commission voted unanimously to close the file, and that's what we're reviewing.
That's correct, Your Honor, but the failed vote on the finding of reason to believe is also not what's the subject of court review, and yet for decades, the DCCC and Common Cause statement of reasons requirement has been structured around what happened in the finding of reason to believe vote. So while the 5-0 vote to close the file is the subject of court review, All of the FICA cases since DCCC are built around what happened in the finding of reasons to believe vote and the votes leading up to the vote to close the file. Here, two commissioners voted to dismiss the allegations under Heckler versus Cheney. Now, anyone familiar with Heckler versus Cheney would know that that is an invocation of prosecutorial discretion and their unreviewable power to decide whether to spend agency resources on this particular enforcement.
But you are acknowledging that the vote on April the 20th was a vote to find no reason to believe that the law had been violated, and that that is reviewable, right?
What's being reviewed here is the 5-0 vote to close the file. The 3-2 vote of finding of reasons to believe informs what the judicial review process looks like. But once the commissioners have invoked their prosecutorial discretion under new models and under Commission on Hope, review is at an end. The court.
Well, let's suppose the facts were the exact same as in a case where the Supreme Court had held 9-0, there was a violation of FICA. And the general counsel pointed all of that out in their memoranda, but yet there was still a vote by two commissioners that there was no reason to believe that there had been a violation of the law here. We couldn't review that at all?
If there is no indication in the record.
Just because they later said we're exercising our prosecutorial discretion to vote against Enforcement Act?
Well, that's the consequence of this court's decision in new models, that when the commissioner explains.
So the answer to my question is no. We couldn't review that. If they said, yeah, we know that this case is on all four with the case that the Supreme Court decided last week, 9-0, that said that this was a violation of FICA, but we don't think that there's a reason to believe that there's a violation of law here. We wouldn't review that at all because they later said prosecutorial discretion. Yes or no?
You would not review it. That is correct. If the controlling commissioners explain that their decision not to pursue the allegation was based on an exercise of prosecutorial discretion, new model says that that is an unreviewable decision.
You really want to go down this road because I got a whole bunch more questions. I give you a chance to decide whether you really want to go down this road.
I believe that's the consequence of new models, but I would point out that in this case, it's not necessary for the court to decide whether the vote alone is sufficient.
So let's suppose they said, well, it's the third Tuesday of the month, and we're not going to vote for enforcement ever on the third Tuesday of the month. And we're exercising our prosecutorial discretion to do so. That's unreviewable.
It's possible that if the agency is acting in a way that violates some other.
Yes or no? That's reviewable, yes or no?
I don't believe it would be. I think new model says that when the agency invokes their prosecutorial discretion, that reasoning cannot be disaggregated from other reasons.
Okay, so they say, well, these people who are accused of the campaign violation are white, but if they were black, we would vote to enforce, but because they're white, we're not. And we're invoking prosecutorial discretion. Reviewable, yes or no?
I think that could be reviewed in litigation. I don't think it would be a FICA challenge. I think there would be another source of substantive law showing that what the agency did there was unlawful, in that case, because it was discriminatory in violation of the Fifth Amendment and various other federal laws.
So they say, well, the alleged violation was by someone who's of the same party as we are. So we think that there's no reason to believe, and we're not going to bring an action to enforce. But if they were from the opposing party, we would definitely, and we have multiple times in the past, voted for enforcement, but we're going to invoke our prosecutorial discretion not to, in this case. Reviewable under this, yes or no?
No, and I think that concern is what informed a lot of the contention in this court in new models and Commission on Hope, and in the disputed en banc votes in both of those cases. And the panels in both Commission on Hope and New Models say that when prosecutorial discretion is invoked, that is unreviewable. The court is not to review it for an abuse of discretion standard. So it doesn't matter.
What about the language in Common Cause, I think, that says that, one of the things that we have to see is whether they're treating like cases alike, because that's the essence of arbitrary and capricious action, is not treating like cases alike.
That's correct, Your Honor.
Did we say that there?
Yes, that's correct.
Can one panel overrule another panel?
One panel cannot overrule.
So isn't that still good law?
It is still.
So how is that consistent with your answer of no, that we couldn't consider where the commissioners say, well, because they're the same party we're from, we're not going to enforce, but if they were from the opposing party, we would, and we have on multiple occasions.
If that is the only reasoning that is offered, that would be.
And well, they say prosecutorial discretion.
New Models and Commission on Hope point to long-running case law saying that the court cannot disaggregate a reviewable reason from an unreviewable reason.
So is your answer to my question yes or no? No? Not reviewable?
If the commissioners have invoked their prosecutorial discretion, it is not a reviewable decision. What?
Okay. You go ahead. I'm going to slightly change the subject. You keep going.
I was going to point out that in answer to your question to my friend about what would happen on remand, Common Cause here is helpful because it shows that what's being asked for in the statement of reasons is an explanation of why the commissioners acted the way they did previously. It is not an invitation for the commission to entirely do a do-over. And you can tell that because the court talks about the practical difficulty of asking one of the dissenting commissioners in Common Cause to offer an explanation because he was no longer on the commission. And if they were asking the commission to entirely redo the vote, that wouldn't have been relevant at all. The new commissioners would have considered it entirely. But instead, the court said that it would be a useless exercise and that they were unsure that they even could ask such a statement of reasons from the commissioner who had departed, making clear that what they were asking for was an at the time of the vote explanation of the statement.
Okay, so I have a couple of questions about just about this question of whether the district court could consider the explanation from the two controlling commissioners. All right, so my original reaction when I looked at this, just skimming the briefs, I thought, well, what's the problem? It's the same two commissioners. It's the same reason. It's really before any litigation got started. What's the problem? But then I went back and I looked at Common Cause, and Common Cause gives three reasons for why the statement should be at the same time. And one of those is to promote, quote, reasoned decision-making by the agency and, quote, create an opportunity for self-correction. So that's one reason to require the statement to be at the same time. And that's our circuit law, right? That's binding circuit law. So isn't it obvious that allowing the district court to consider a statement that was filed after the lawsuit was filed, it's completely contrary to this point. It doesn't promote reasoned decision-making, and it doesn't create an opportunity for self-correction.
Well, I think that...
Let me just say one more thing. I resonate to that because I can't tell you, we all as judges have this experience. We decide a case at conference and we set about to write our opinion, and we later discover, wait a minute, as we say, it doesn't write, and we reach a different result, or we reach the same result with a completely different rationale. That's what this language is all about. And that is what allowing the controlling commissioners to file their statement later denies the commission that opportunity.
I think the commission had that opportunity here. At the time that this vote took place, the commission had only recently regained a quorum. It was facing a backlog of 446 matters, of which 275 were pending before the commissioners themselves. Now, prior to the vote, the general counsel's report had been exchanged, and the dissenting commissioners had exchanged internally edits on the general commissioner's report. They referenced those in the statement of reasons, which they later released, which shows that they had meaningfully engaged with their decision to invoke prosecutorial.
But we don't know that. I mean, that's certainly one view of it, but if the commission had been required to issue their statements 30 or 40 or 50 days later, who knows? They might have changed. They might have taken a harder look at the record. Just as writing an opinion disciplines our thinking, writing their explanation might have disciplined theirs. And this is, you know, as I said before, the DC Circuit's been making this stuff up for decades, right? And this is a controlling decision, common cause. And this reason is controlling. And therefore, when I look at this, I have to ask myself, will allowing a late commission, controlling commission file accomplish this purpose? And it seems to me, obviously, it won't.
Well,
and you haven't given me a reason as to why, other than your hypothesis that maybe in this case they had already considered the position. We don't know that.
well, two responses to that, Your Honor. The first is that, as Your Honor observed, this is the statement of reasons requirement is something that is a product of this court's case law.
Right.
It is not found in FICA.
Correct.
And it is not found in the APA.
Correct.
And I think there's a considerable question under Vermont Yankee.
I agree with that too. But I agree with that too. But common cause is the law of the land, at least for us right now.
And what common cause
Right.
says, this is in note 32, is that the statement of reasons need only be adequate to allow for judicial review. Now, the cases that are.
But it says more than that. It gives these three reasons. And one of the reasons is the one I read to you. And we don't pick and choose the parts of our opinions we follow. I mean, this is a critical part of the opinion about the need to promote reasoned decision-making and self-reflection. And I don't see how we can carve that out. It said there are three reasons for this. This was one of them.
That is one of them.
Yeah.
The timing in which this statement of reasons was released is perfectly in accord with that requirement, because the commissioners review the general counsel's report, they prepare comments on it, they go into executive session where they're going to be voting on a great number of matters, and absent going in with a pre-prepared statement of reasons for each,
Okay.
asking for a contemporaneous release would simply delay agency action on these pending matters, some of which were imperiled by the statute of limitations.
Well, it could be issued within the 60-day period.
It could be issued within the 60-day period, but I'm not sure where that requirement would come from. And
Well, it
it's
would come from the statute. They have 60 days to challenge it, so they've got to get it out within 60 days. And again, we're making this stuff up. So what makes sense? Well, that sort of makes sense. But let me take, I could think of two more reasons why requiring a statement at that time within that 60 days makes sense. But maybe you can tell me why that's not the case. One is the one that counsel petitioners made, which is, it seems completely unfair to allow the commission to sit back and wait to see whether someone challenges a decision and then issue their controlling statement in a way that reflects the theory of the petitioner's complaint. In other words, it gives them a chance to shape their explanation in view of the type of lawsuit that's been filed. That's one reason. And the second reason is that I assume that in some circumstances, a complainant would take a look at the controlling commissioner's explanation and decide not to sue. And then we wouldn't be wasting our time and resources considering just this question, right?
certainly, Your Honor. And when citizens.
But aren't those two awfully strong reasons for requiring the statement to be issued within the 60-day period?
I think there are particularly strong reasons when there's no invocation of prosecutorial discretion. Because if the question is whether the commission's legal reasoning is sound, then certainly that kind of analysis may be helpful to a litigant. But at the time Citizens United filed this lawsuit, they already knew.
But then under that theory, that eviscerates the requirement for the commissioners to give a statement, even if they're exercising prosecutorial discretion. Why did we require that? Except because we think it's necessary for judicial review.
Because as New Model says, the invocation of the length of the invocation of prosecutorial discretion is not dispositive or even particularly relevant. So in a vote where there is no heckler vote, where there is only a vote to close the file, that certainly is a void, and Citizens United would have a difficult choice there to make about whether to file a lawsuit. But here, at the time that they filed their complaint, they knew the two controlling commissioners had voted to dismiss under Heckler versus Cheney. Now, they did not have a lengthy explanation of that invocation, but I don't see why that's necessary, because this is a different analysis in kind than the sort that's taking place in State Farm or in the other cases where this court has reviewed what the commission has done. The review, when the commission has acted in its prosecutorial discretion, is not whether that invocation was reasonable or whether it was consonant with the record. It's simply whether they chose to exercise that discretion or not.
So under your theory, is there any, we were discussing with Counselor Petitioner when he would require the statement to be issued. Is there any limit to your theory? I mean, could, under your theory, could the controlling commissioners issue their statement? Here they issued it, what, 4 days after the complaint was filed or
That's
something
correct.
like that? Okay. Could they have issued it, say, while the district court was considering motions for summary judgment?
I think that I would point, Your Honor, to two.
Yes or no?
Possibly, yes.
Okay, could they have issued it after the district court decided the case and while it's on appeal?
I think Regents suggest
Yes or no?
that would be a much closer call.
You think that's close?
How
How while this court's considering the case?
There may be an outer bound on.
What is it?
I don't think it's necessary for this court to decide that.
Yes, it is, actually. It is necessary, because when we decide a case, we have to understand what the consequences of it are. And if we're going to decide, if we're going to agree with you that this statement is adequate, we have to know what the limits of that are. We can't just decide that and put off for another day what we think about the possibility of it being filed later. True, we don't have to decide that question, but we do need to understand the consequences of our decision. That's why I'm asking you the question.
Certainly. I would point, Your Honor, to this court's recent decision in Campaign Legal Center. That's 31 F. 4th 781. This court's decision was about standing, but on remand, the district court did engage with the adequacy of the statement of reasons. That statement of reasons was released on August 21st, and the complaint was filed on August 2nd. Now, the question of timeliness was not litigated there, but what that shows is that sort of gap in time does not preclude effective judicial review.
I wasn't asking you about that gap. I was asking about a later gap. How about while the district court is considering the case, or after the district court have decided it, or even while we're deciding?
Well, Regents would suggest that that may be a different consideration, because the Nielsen Memorandum was released after multiple district courts had enjoined the agency action, creating a much stronger suspicion that the additional reasons that Secretary Nielsen was offering were created in response to adverse court orders. But the court nevertheless considered the Nielsen Memorandum to the extent it was expanding on what was already present in the Duke Memorandum. Here, the statement of reasons is expanding.
It didn't consider it. It rejected it.
It considered.
It said that because there are new reasons that weren't in the Duke Memorandum, we're not going to consider it.
So it looks at the Nielsen Memorandum and says there are three bases offered in the Nielsen Memorandum. One is a repetition of what was said in the Duke Memorandum, that the order there was unlawful. The second and third were not present in the Duke Memorandum. The Chief Justice engages with the first reasoning in the Nielsen Memorandum. He finds it unpersuasive because the Nielsen Memorandum doesn't seem to recognize the Secretary's discretion to continue to withhold deportation without the other consequences of that, which was the basis of the unlawfulness finding. But the Chief Justice does not disregard the Nielsen Memorandum in its entirety. So there you have the same thing present here, where the initial record has some indication of the agency's reasoning. A later supplement is released that expands on that same reasoning and that provides for adequate judicial review. And I would finally add that a remand here would serve no purpose, and this court's decisions, including EnviroCare, make clear that a remand is not necessary when the agency would simply reoffer the same reason that it already has, and the review would be at an end.
Suppose, I'm sorry to ask this question, but I'm sure you get questions like this all the time. Suppose we agree with petitioners here that the district court should not have considered this. What should we do? What's the proper? District court said, well, if you do that, he's just going to remand it to the agency to reissue it, basically, right?
That's right. I think you should nevertheless affirm, and EnviroCare shows why. Because there, the agency, the question was whether the agency had correctly excluded an intervener from participating before the agency. And the agency said, this intervener does not meet the judicial legal standard for standing, and therefore we're not going to allow them to participate. During litigation, the agency additionally argued, we're not bound by the judicial requirement for standing, and we would exclude him anyway. The court said you were wrong about the legal standard for standing, but if we remand to the agency will exercise its discretion to exclude the intervener regardless, and there's no point in such a remand.
And how's that play out here?
Well, how it would play out here is End Citizens United is suggesting that the agency action is unlawful because it's unexplained. The commissioners have since...
It was unexplained at the time of the decision.
It was unexplained at the time of the decision. That's their contention, certainly. I disagree because of the Heckler vote, but...
I know, but let's assume you're wrong about it.
Certainly. The commissioners have released their statement now, and if you were to remand, as under Common Cause or DCCC, to ask for an explanation of why they took the vote they did when they voted to close the file, they would simply reissue the exact same statement.
But if our reason for finding it unacceptable is because the filing of a late statement is inconsistent with reasoned agency decision-making and the opportunity for self-correction, having them reissue it now instead of a month later, 2 years later, doesn't solve that problem. It's still too late, isn't it?
It's still too late, but it's the remedy that Common Cause and DCCC contemplate.
No, it's not. Oh, I'm sorry. Go ahead.
Neither of those cases ordered a vacatur and a redo. And that's why in Common Cause, there's discussion of the availability of Commissioner Wright. The question is, what was the reason for the vote at the time the vote took place? Here, I'm sure that the controlling commissioners would offer the exact same reason that they have already offered and that the district court considered. So a remand would serve no purpose, and unless there are further questions.
Judge Rogers, any further questions?
No, I'm fine. Thank you.
So I just want to go back to your view of how we should look at Heckler v. Cheney, which is, Heckler v. Cheney, the court itself said that prosecutorial discretion and enforcement decisions, there's a presumption of non-reviewability, right?
That's correct.
That term. And it doesn't say it's an irrebuttable presumption. The presumption, by definition, means that there are circumstances to overcome the presumption. You would agree with that?
I would. And Heckler itself contemplates that a complete abdication of agency responsibility may lead to the presumption falling away. But this FICA-specific challenge is not an avenue for bringing such challenge. And Citizens United has not argued that here. And if they wanted to, they could do so through writ of mandamus proceeding, through facial challenge to the agency under 706A. There are other avenues available for them than making such an argument in this specific case.
So the reason I'm trying to drill down on this is that one of your arguments in your brief is that even if we don't consider the subsequent statement, we can just look at what they said on April 20th and April 22nd, and that is sufficient under our precedent to allow review because they invoked Heckler v. Cheney, so we know that they were invoking prosecutorial discretion. That means then we know that there's a presumption of non-reviewability, but if we don't know anything about the basis for exercise of that discretion, how can we evaluate whether that presumption might be overcome by what their views?
I don't think the Heckler presumption is case specific in that way. I think the Heckler presumption is this type of agency action reviewable? In New Models and in Commission on Hope, this court looked at the FECA and said there is no law for us to apply to the agency's decision of whether to use its prosecutorial discretion. So I don't know that you could say in a particular case the heckler presumption doesn't apply. I think
I don't understand how that argument can preclude evaluating whether the prosecutor correctly interpreted the substantive law that governed their decision. So, for instance, if it were just a very simple, crass example, if you had a criminal prosecutor who said, well, there is a rape statute, but I believe that rape can't occur between a husband and a wife when they are married. And so I'm not going to exercise my prosecutorial discretion ever to prosecute a husband for raping his wife. You're saying that a court can't look at that and say, well, the statute doesn't say that, so you are reading something into the statute that's not there. We may or may not agree, but you're just saying that the court has no role there. There's no law for the court to apply.
I wouldn't say that, Your Honor, because there are few, to be sure, but there are a handful of cases where agencies have adopted policies like that are prosecutorial policies across a number of fields. And those have been subject to review through court proceedings, notwithstanding heckler, in order to determine whether those policies are an abdication of the agency's responsibility. I could also possibly see, for example, a take care clause violation that could be implicated by an agency entirely saying we are no longer going to enforce a particular category of law or regulation going forward. But that doesn't speak to here where.
Well, my point is that if you acknowledge that, then if someone challenged a declination of prosecution where there was a husband who, let's say there's a videotape of the incident that seems to compellingly show that there was a rape of his wife, and the prosecutor just uses the magic words, under my prosecutorial discretion, I'm not prosecuting them. You're saying that that would be the end of the matter because he used those magic words? Because the presumption, there's a presumption, and as soon as he uses the magic words, it's effectively irrebuttable?
I think there are other checks on a prosecutor who has abandoned his duties in that way, that there are modes of supervision, of removal, of oversight. I'm not sure that FECA applies such a standard here. And in fact, in New Models, this court has said that FECA does not provide a standard to govern the commissioner's exercise.
But I mean, it's black letter law since the beginning of time that it's an abuse of discretion for an official to exercise their discretion based on an erroneous view of the law, right?
That's correct. And Commission on Hope says that the court is not reviewing the commissioner's decision on an abuse of discretion basis. It is an unreviewable decision, which is different in kind from the ordinary type of abuse of discretion review, which would necessitate a longer explanation than simply a failed vote to dismiss under Heckler versus Cheney. But because once the commissioners have acted in exercise of their prosecutorial discretion, it is entirely.
So prosecutorial discretion can be abused under the traditional abuse of discretion standard, and that's what Heckler v. Cheney stands
for. I'm not sure that it does stand for that. Certainly that's intention.
Is that your argument?
No, it's, and if I've misled Your Honor, I apologize for that. But in Commission on Hope, the court says that you are not reviewing the agency's decision under an abuse of discretion standard. Instead, it is an unreviewable decision. So it does not even particularly matter how reasonable the exercise of prosecutorial discretion is. It simply matters that the agency is in fact exercising its prosecutorial discretion and says that is the basis for its action, which was clear here.
So we've gone from presumption of non-reviewable to just unreviewable under any circumstance.
The presumption of non-reviewability is, in general, when we look at an agency a fortiori and try to decide, does this agency have, is this agency's decision to exercise prosecutorial discretion subject to review? Under a particular statute, it could be. A statute could say the commissioner shall do A, B, and C after considering these factors. That's not what FICA says. And in Commission on Hope, because of that, and in new models, this court has said that FICA gives no law to guide the commissioner's decision. And as a result, the commissioner's exercise of prosecutorial discretion is a question that is committed solely to the agency and is unreviewable by a court.
I suppose the FEC decides that for any exercise of prosecutorial discretion, they will not issue any simultaneous statement other than the controlling commissioner's exercise of prosecutorial discretion, period. That's it.
I think this was partly what drove the dissenting opinion in new models. Now, they are
But what about now under our case law? Suppose the commission just adopts that policy, and now we get the next case in the series. We get the first one of those cases. And the district court has found that that's okay because exercises of prosecutorial discretion are unreviewable. Comes up to us. What do we do with our requirement that the commission issue, that the controlling commissioners issue an explanatory statement?
So that is not present in this case because of the subsequent statement. But setting that aside,
that's why I started my question with support.
Certainly. I believe that would be an adequate explanation by the agency because new models and Commission on Hope ask whether prosecutorial discretion was invoked, not whether it was invoked reasonably. It is an unreviewable decision once the commission has chosen to exercise prosecutorial discretion not to pursue an enforcement proceeding.
When you put your chips to the middle of the table, you put them all in, right?
Right.
I don't want to play poker with you.
Respectfully, the decision of the district court should be affirmed.
Thank you.
Thank you, Your Honor.
All right. Any other questions, Judge Rogers?
No, thank you.
David?
No.
All right. Thank you, counsel. All right. Mr. Hancock, I was joking earlier. Of course, we'll give you time for rebuttal. We'll give you 3 minutes.
And if you weren't already planning to start with a response to the discussion we just had, would you? Suppose the commission adopts the practice that I just described. Exercises of prosecutorial discretion require nothing more. They satisfy their obligation, give a contemporaneous explanation by stating that that's what they've done.
I think that would be unpermissible under this court's case law, especially under new models. I think the basis for the exercise of prosecutorial discretion still matters, even though if it is effectively invoked, it can insulate a commission dismissal. And the primary reason for that is the fact that if a commissioner just says prosecutorial discretion, the magic words, it's not effective if the reason why the commissioner is doing that is because they have an interpretation of FICA that can validly be challenged under FICA's contrary to law standard. That's what makes FICA unique and the FEC unique from other agencies. And new models of Commission on Hope still make clear that interpretations of FICA and the view on the merits that result from that are still reviewable under the contrary to law standard, despite the fact that prosecutorial discretion can, in some instances, insulate a dismissal. And I think the application issue that your honors were referencing has important implications for the issue of the timing of the statement of reasons. So, if controlling commissioners, if failing to go forward commissioners are able to wait until the 60-day deadline passes to see if litigation is filed, to then file a statement asserting prosecutorial discretion to kill review of a lawsuit, they would be able to effectively only do that when necessary. If they're required to issue a statement at the time of their actual dismissal, and they want to insulate every single dismissal, they'll be forced to assert prosecutorial discretion every time, and they will open themselves up to allegations that they've abdicated their law enforcement responsibility, which would be, of course, an exception to Heckler and would pierce the presumption of unreviewability established by Heckler. So allowing these late statements would effectively allow them to dodge allegations of abdication. Now, of course, we haven't brought an abdication claim in this case, but that's beside the point. I think the incentives set up by the district court's ruling would allow for that.
I just want to clarify something. I saw maybe 2 paragraphs in your brief that challenged the substance of the subsequent statement. But I don't really see any real challenge that if we consider those statements that they reveal something contrary to law.
Before the district court, we argued that the invocation of prosecutorial discretion in that late statement was ineffective. The district court ruled against us, and we decided not to appeal that aspect of the district court's ruling.
Okay, just wanted clarification on that.
Unless your honors have any additional questions.
Judge Rogers?
Oh, thank you.
All right, we will take the case under advisement. Mr. Casaza, you were appointed by the court to represent the appellees in this case, and we thank you for your very able assistance.
Second.
I agree.